Members of the Senate and guests will please rise as we receive our distinguished president.
The Senate will please come to order. Members and guests will remain standing while we're led in our devotion by the chaplain, followed by the Pledge of Allegiance. Chaplain.
In Matthew, we read that the Lord himself very clearly said, "Truly I tell you, just as you did it to one of the least of these who are members of my family, you did it to me." From Matthew chapter 25, verse 40. Please bow in prayer with me. Gracious and ever-loving God, we note that the UN's World Interfaith Harmony Week begins today. And you have made it clear, O Lord, that we all truly have a role to play in reaching out to those around us who are less fortunate than we are. And of course, it is not only those around the globe who often suffer. There are sadly far too many of our sisters and brothers, even children, here in South Carolina who struggle with the burdens of all sorts. It is a reality that rests on the shoulders of all of us. We each should be motivated to aid the unfortunate whenever and wherever we can. So the heart of our prayer today, Lord, is that these senators and other leaders will seek meaningful ways to aid the needy, thereby making life better for all. We humbly ask this in your loving name, dear Lord. Amen.
I pledge allegiance. Please be seated. Senator from Lexington, Senator Cecil, what purpose you rise? Quorum has been questioned. Clerk will count. "15 members are present. A quorum is not present." Senator from Lexington.
Lawrence.
Unanimous consent for the leave for the senator from Lawrence, without objection.
I ask for a call of the Senate.
Call of the Senate. The clerk will ring the bell. The clerk will call the roll.
Mr. Adams, present. Mr. Alexander is present. Mr. Allen, absent. Mr. Bennett is present. Mr. Campson, absent. Mr. Cash. Mr. Cash is present. Mr. Clymer is present. Mr. Corbin, absent. Mr. Cromer. Mr. Cromer is present. Mr. Davis, absent. Mr. Fanning, absent. Mr. Gambrell, absent. Mr. Garrett. Mr. Garrett is present. Mr. Goldfinch, absent. Mr. Grooms, absent. Mrs. Gustafson is present. Mr. Harpootlian, present. Mr. Hembry, present. Mr. Hutto, absent. Mr. Jackson, absent. Mr. Kevin Johnson, absent. Mr. Michael Johnson, present. Mr. Kimbrell is present. Mr. Kempson, Absent Mr. Loftus. Absent Mr. Malloy. Absent Mr. Martin. Mr. Martin is present. Mr. Massey is present. Mrs. Matthews. Absent Mr. McElveen. Absent Ms. McLeod. Absent Mr. Peeler. Mr. Peeler is present. Mr. Rankin. Absent Mr. Rice. Mr. Rice is present. Mr. Sabb is present. Mr. Scott. Absent Mrs. Sin is present. Mr. Setzler is present. Mrs. Shealy. Mrs. Shealy is present. Mr. Stevens is present. Mr. Talley, present. Mr. Turner is present. Mr. Verdon has leave. Mr. Williams. Mr. Williams. Absent Mr. Young. Mr. Young is present.
Have all members voted? Senator Kevin Johnson is present. Senator Fanning is present. Other than Senator Davis is present. Have all members answered the roll? Have all members answered the roll? Senator Malloy is present. Senator Williams is present. Have all members answered the roll? Polls are closed. The clerk will tabulate. Okay. 30 members are present. A quorum is present. Senator from Edgefield is recognized.
Mr. President, I want to take an opportunity to just make an introduction real quick. I think most people have noticed already, but we have with us this afternoon former Governor, United States Ambassador to the United Nations, Nikki Haley is with us this afternoon. Just want to stop by and say hello. So, Mr. President, if we could we just stand at ease for a couple of minutes just to allow everybody to greet the ambassador?
Without objection, we'll stand at ease for a couple of minutes. Senate will come to order. Governor, Ambassador, it's an honor to have you visiting with us here in the State Senate today. We appreciate your service. Thank you. Are there any petitions, memorials, presentments of grand jury or such like papers? We have communications. The clerk will read.
Message from the Governor, Mr. President, members of the Senate. I'm transmitting herewith the following appointments for confirmation. These appointments are made with advice and consent of the Senate and therefore submitted for your consideration. Statewide appointment, member of the State Ports Authority at large, Ms. Felicia Rue Howard of Columbia.
Transportation Committee.
Member, South Carolina Jobs Economic Development Authority, 1st Congressional District, Mr. Henry B. Fishburne, Jr. of Charleston.
Labor, Commerce, and Industry.
Appointment to the Governor's School for Agriculture at John Delahouse School Board of Trustees at large, Ms. Yvonne C. Knight Carter of Moncks Corner.
Education Committee.
Member of the Commission on Disabilities and Special Needs, 4th Congressional District, Ms. Robin B. Blackwood of Greenville.
Medical Affairs.
Member of the State Housing Finance and Development Authority at large, Mr. Carl A. Haslinger of Gilbert.
Labor, Commerce, and Industry.
Member of the Board of Occupational Therapy, Ms. Nadine Hanner of Somerville.
Medical Affairs Committee.
Member of the Veterans Trust Fund of South Carolina at large, Ms. Nancy B. Dunn of Inman.
Family and Veterans Affairs.
Member of the Veterans Trust Fund of South Carolina at large, Dr. Nikki Wooten of Columbia.
Family and Veteran Services.
Member of the South Carolina State Commission for Minority Affairs, 1st Congressional District, Mr. Calvin Whitfield of North Charleston.
Judiciary Committee.
Reappointment as chairman of the Workers' Compensation Commission, Mr. Thomas Scott Beck of Prosperity.
Judiciary Committee.
Member of the Foster Care Review Board, 4th Congressional District, Mrs. Jane W. Daniel of Greer.
Family and Veteran Services.
Reappointment of a member of the Foster Care Review Board, Ms. Jane W. Daniel of Greer.
Family and Veteran.
Member of the Foster Care Review Board, 5th Congressional District, Mrs. Mary D. Long of Camden.
Family and Veteran Services Committee.
Appointment to State Ethics Commission, Mr. F. Xavier Starks of Columbia.
Judiciary Committee.
Initial and reappointment of a member to the State Housing Finance and Development Authority, at-large chairman, Mr. C. Todd Latif of Clemson.
Labor, Commerce, and Industry. We have no further communications. Therefore, we are on introduction of new bills and resolutions. The clerk will read.
Introduction of a bill by Senators Campson, Grooms, and Sin. It amends the code relating the office of Register of Deeds so as to provide qualifications to be eligible to hold the office of Register of Deeds.
Senator from Charleston, what purpose do you rise?
I'd like to make some introductory or some explanatory remarks.
Recognized for up to 3 minutes. Senator from Charleston, please give him your attention. Senator from Charleston.
Thank you, Mr. President. Mr. President, this bill that was just introduced deals with establishing qualifications for Register of Deeds in the state of South Carolina. We used to call them RMCs, the Register of Means Conveyance, which is the old English law idea. But now we call them Register of Deeds. And there currently are no qualifications for a Register of Deeds. We've had some issues in Charleston County on getting documents recorded in a timely fashion, and that's probably an understatement. in documents like deeds and mortgages and mechanics liens. Very, very important that they be filed in a timely manner. We are a race, we are a race filing state, race notice state. Yeah, race, sorry, took property law a long time to go in law school, but race notice is the term, but the first to file has first priority. So, for example, if you satisfy a mortgage currently on your property because you want to refinance, and that first mortgage is not satisfied for, in Charleston County, we're up to 60 days, almost 60 days, things being behind as far as filing. You can't take down the second mortgage. You can't draw down on your second mortgage because the first mortgage has to be satisfied before the second. In a 1031 tax-free exchange transaction, the Internal Revenue Code says that you have 180 days to find replacement property if you're going to have a tax-free exchange, and the date of the filing of the deed is the date that determines whether you met the 180-day period or not. So 1031 exchange transaction, people may lose hundreds of thousands, some probably in Charleston, some millions of dollars of tax liability. They may lose the tax deferral on millions of dollars. And mechanics liens, the same thing. They're not perfected until they're filed. So someone who's done some work on a home, they don't get paid. They don't have a mechanics lien. They've delivered it to the office, but it's not been filed. That small business subcontractor is just out of luck. And so this creates qualifications. You got to be a citizen of the United States and the state. You have to be a qualified elector in the county. You have to have either a 4 years bachelor degree or 4 years experience in the field of law, real estate, or accounting, or as an employee, 4 years in the Office of Register of Deeds. Existing Register of Deeds are grandfathered in, but another qualification is you must have complied with Section 3590, which is a state law that requires, it's not optional, requires you to record documents within 30 days of receiving those documents. Charleston is 59 days behind. Other counties, the biggest county for the most deeds recorded, did some research, is Horry County. They've had 26,000 transactions in the last 12 months. Charleston's only had 15,000. And Horry records their deeds the same day. So it can be done. It can be done through COVID. It can be done through the pandemic. It can be done through all these travails that we've experienced in the last few years. And it is being done elsewhere in the state, but it's not being done in Charleston County. So the last provision of this bill is this. A quo warranto action may be brought in accordance with the provision of this bill to determine whether a Register of Deeds is eligible to hold the office. So basically what it provides is that a quo warranto action is an action when you challenge someone's right to hold office. For example, they're typically filed when someone is elected to in a district, a legislative district, a school board district, and they don't live in the district. Anyone can bring an action and say you're not eligible to hold this office. So this creates this cause of action if you have a pattern of failing to comply with the 30-day filing requirement. This is very important for commerce. It's very important for the business community all over this state. Charleston, we are way, way behind in these filings. It's causing tremendous turmoil in the real estate industry and the legal community. We've had the president of the Charleston Bar weigh in on this with a very strongly worded letter about the problems that we're having in Charleston County. This is a statewide bill. It has to be a statewide bill to pass constitutional muster because of the constitutional prohibition against local legislation. So this is good for all counties in the state because these are qualifications, but they're not excessive qualifications. But if you don't meet the qualification of filing your documents within 30 days, any individual could bring a cause of action to remove you from office because you have failed to meet this newly established qualification for the office.
Senator from Berkeley, what purpose do you rise?
See the Senator answer a question.
Senator Yield for a question?
Yes.
Isn't
Yes,
it true
Senator
this
Yield.
legislation grandfathers all the RMCs in this state?
It grandfathers existing RMCs in the state, except for the provision that you have to file your documents within 60 days. That you don't get grandfathered in if you have a pattern of violating that requirement.
So everyone in the state would be grandfathered except for an RMC that is either unable or unwilling to file the deeds in a timely fashion
And has demonstrated
as
a
prescribed by law.
pattern of doing that. It's
Pattern.
not just
One or two
one or
times.
two times.
It's
And virtually everyone in the state's doing it. But that would be the only, so you could be removed for that purpose. But the bachelor's degree requirement, the 4 years experience in law, real estate, or accounting, you're grandfathered in if you don't have that.
Or 4 years.
But 4
working in
years
the
as an
office.
RMC is a qualification. So any existing RMC who served 4 years would qualify as long as they haven't violated the 30-day filing requirement. The 30-day filing requirement. And what this does, I mean, there's a lot of talk about just having the governor remove individuals who are not filing within 30 days, county council remove, and this gives the individual a day in court. This is really important. This is a due process. This provides due process. A judge would have to make this determination. It would not be a jury trial. It would be a judge would make it, and I'm confident the Supreme Court, if someone were removed under a quo warranto action, would probably provide expedited process and take the litigation without going to the circuit court.
Thank you for filing this common sense legislation.
Thank you, Mr. President.
Thank you. Thank you,
Mr.
Senator.
President, I'd like to also just recognize Jenny Huddycutt, who's in the antechamber, who is a member of Charleston County Council, and also the daughter of my very good friend, Dr. Louis Costa, who I've introduced many times in this chamber. But y'all go say hi to Jenny Honeycutt, member of Charleston County Council.
Glad
And
to have you
I've collaborated with her on this, and she thinks it's a good idea as well. But thank you.
Thank you, Senator. Glad to have you with us. The bill is referred to the Judiciary Committee. The clerk will read.
Introduction of a bill by Senator Martin. It amends the code, adds a section to create the Illegal Immigration Enforcement Unit within the South Carolina Law Enforcement Division, provide for its administration and duties, to require a memorandum of agreement with U.S. Immigration and Customs Enforcement.
Senator from Spartanburg, what purpose do you rise?
To be heard for introductory remarks.
Senator from Spartanburg, Senator Martin is recognized for up to 3 minutes on his introductory remarks on the bill.
Thank you, Mr. President, members of the Senate. I want to talk about this bill. Last year in our annual appropriations or budget, there was a proviso that transferred the Illegal Immigration Unit from DPS to SLED. I let it go because it was technically a Rule 24 violation that most of y'all know that I generally raise and will continue to raise. But I let it go because both agencies really wanted it done this way, and it seemed to make sense through all our committee work on the finance side that it needed to be done this way. So what I asked them, both the Director of Department of Public Safety and the Chief of SLED, I asked them to get together, work together, and come back and bring me language that I could have drafted into a bill to put in statute what we agreed to in the budget. And so I wouldn't have to raise the Rule 24 again this year. So what this bill does is just what we've been doing in the budget. It puts in statute the Legal Immigration Unit, moves it from DPS to SLED. So even though this is kind of simple, committees have kind of worked on this before, I'm not up here asking for it to go without reference or on the calendar, but I have talked with the Chief of Staff of the Judiciary. I haven't seen the chairman yet, but I will talk to him. But staff is well aware of this issue. They're well aware of it. So all I'm hoping is for those of you on Judiciary that we try to get this something back to the floor. I'd really like to get it done before the House takes up the budget and starts the proviso route. I want the statute to be correct. So that's all this bill does. So I just wanted to let everybody know. Thank you, Mr. President.
Thank you, Senator from Spartanburg. The bill is referred to the Judiciary Committee. Clerk will read. Senator from Lexington, what purpose do you rise?
Mr. President,
Yes, sir. What purpose
ask
do you rise?
unanimous consent for leave for the senator from Richland, Senator Jackson.
Without objection. Senator from Clarendon, what purpose do you rise? State your request.
I want to ask for leave for the senator from Sumter, Senator McElveen.
Senator McElveen, without objection. Leave is granted. Thank you. The clerk will read.
Introduction of a bill by Senators Kimbrell and Shealy. It amends the code relating to the relations of Secretary and County Veterans Affairs officers to make provisions for monthly reporting and amending further sections relating to semi-annual reports.
Family and Veteran Services.
Bill by Senator Gambrell. It amends the code, adds a section to authorize central fill pharmacies to be established in the state for the purposes of filling prescriptions for and at the request of an originating pharmacy to establish certain operating procedures.
Medical Affairs Committee.
Introduction of H 4872. It's a concurrent resolution to recognize and commend South Carolina's FFA members, formerly known as Future Farmers of America, and all who support, promote, and encourage these outstanding students of agricultural education, and to join them in observance of National FFA Week, February 19th through the 26th, 2022.
Agricultural and Natural Resources Committee.
The Labor, Commerce, and Industry Committee has reported favorable with amendments on H 3606. This is a bill which adds a section to the code to exempt certain improvements made to residential property from building permit requirements, to exempt property owners who make such improvements from Residential Builder Commission licensure requirements.
Placed on the calendar.
Education Committee reports favorable with amendments on S712, bill by Senator Davis. It amends the code relating to educational scholarships, adds an article to establish the Healthcare Professional Loan Forgiveness Program to provide for the eligibility, administration, and funding of the program.
Placed on the calendar.
Education Committee reports favorable with amendments on S946, bill by Senator Goldfinch. It amends the code relating to duty-free lunch periods for public and elementary school teachers so as to instead provide unencumbered time for elementary school teachers and teachers who instruct certain students removed from the general education setting and provide related requirements.
Placed on the calendar.
The Labor, Commerce, and Industry Committee has reported favorable on the following appointment: member of the State Athletic Commission reappointment of Mr. Edwin M. Estridge of Chapin.
Received his information.
Labor, Commerce, and Industry Committee reported favorable member of the Residential Builders Commission initial appointment at large, Mr. James Graves of Columbia.
Received his information.
Labor, Commerce, and Industry Committee has reported favorable member of the Jobs Economic Development Authority, 3rd Congressional District, Mr. Richard K. Blackwell of Seneca.
Received his information. The desk is clear. Senator from Clarendon, what purpose do you have?
Mr. President, I have another unanimous consent request.
State your request.
I'd like to request leave from the senator from Colleton, Senator Margie Bright Matthews.
Without objection, leave is granted. Senator from Lexington, Senator Shealy, what purpose do you rise? State your request.
That on the next available day that the Senate adjourn in memory of the former Miss USA, Chesley Christ, who died Sunday morning. She was a student at the University of South Carolina, and she was a law student, and she was a lawyer in New York, and she tragically jumped to her death from her New York City apartment. And as co-chair of the South Carolina Prevention for Suicide, I would like to remind people that there is an alternative, and please call for help if you're depressed, but please remember her and her family this week.
Without objection, next available day. Senator from Anderson, Senator Gambrell, what purpose do you rise?
Thank you, Mr. President. Unanimous consent request.
State your request.
I'd like to pull Senate Resolution 958 out of the Medical Affairs Committee for immediate consideration. It was kind of got by us. It's to recognize January 2022 as Firefighter Cancer Awareness Month in South Carolina.
Is there objection to unanimous consent of recalling S958 from Medical Affairs? And without objection, the question is immediate consideration. All in favor of the adoption of the resolution, please say aye. Aye. Opposed, no. The ayes have it. So ordered. Senator from Williamsburg, what purpose do you rise, sir?
Thank you, Mr. President. Unanimous consent request.
State your request.
Leave for the senator from Charleston, Senator Kempson, until 1 o'clock.
So ordered without objection. Thank you. The senator from Richland, Senator Scott, what purpose do you rise?
Unanimous consent request. Leave from Senator from Richland, Senator Jackson for the day.
So,
oh, you already got it? Thank you.
Without objection. The desk is clear. Are there any requests for local bills? Any request for local legislation? Hearing none, that takes us to page 6. Interrupted debate on S150 by the senator from Beaufort, Senator Davis, and others. Senator from Beaufort is recognized. Please give him your attention.
Thank you, Mr. President. Members of the Senate, it's going to be my purpose this morning or this afternoon early to go through the rest of the bill without interruption, not to imply by that I don't welcome your questions. I do, but I want to get through the entire bill so that we have, an overview of what's being presented, and that might be a more orderly way of then taking up specific questions in regard to sections of the bill. But before I do that, I wanted to talk a little bit about what's happened over the last 4 days, and I really think this is an example of. I'll yield to my friend.
Senator from Lexington, what purpose do you rise? Senator Sassler.
Yield for a request to introduce the doctor today, with you holding the floor.
With the senator from Beaufort holding the floor. Senator yields. Senator from Lexington. Purpose of introduction.
Mr. President, ladies and gentlemen of the Senate, we have in the balcony today with us Dr. Greg Squires from Columbia, South Carolina, a surgeon. He's with the Fellow Association College of Surgeons. He actually grew up next door to me. Where is Greg?
He's right up here to your right.
There he is. And Greg is now the Chief Medical Officer for Nephron Pharmaceuticals in Casey, West Columbia. Greg, we're glad to have you here. Thank you for your service. He comes every year. Give him a round of applause.
Thank you for being here. We appreciate.
And I know what you're going to say.
Senator from Darlington. Yes, sir. Yes, sir. Senator from Darlington, from the introduction.
Thank you, Mr. President, members of the Senate. I've known Dr. Greg since he was a freshman at USC. He and I are in the same fraternity, the University of South Carolina cheerleaders. And so I met him during that time, Brooklyn Casey maybe? Yeah, came out of Brooklyn Casey, had a lot of good times together. He's always been a stand-up person. No surprise that he would end up doing great things in the medical profession. Saw him not too long ago out for dinner and got a chance to end up catching up. And I want you all to end up knowing about part of his history and the fact that we're good friends and that he has made our state proud, and it's no surprise that he would be here serving us today. And so I would join the senator from Lexington in welcoming him to the Senate today. Greg, good to see you.
Thank you. Welcome to the Senate. Thank you for your service. Thank you. The senator from Beaufort.
Thank you, Mr. President. What I was going to say in some preliminary remarks before going through sections of the bill was that over the last 4 days, really since we adjourned on Thursday, there's been some really good work done on this bill in regard to some questions that were posed by the senator from Greenville, Senator Loftus, and the senator from Charleston, Senator Campson, and others in regard to why could we not, instead of establishing a new system or network of dispensaries to get medical cannabis in the hands of individuals who had been authorized to have it by their physician, why could we not take advantage of the skill and expertise that pharmacists possess, and particularly in regard to their ability to interact with patients at the dispensing level, to answer questions by the patients in regard to the medication, to be a source of information for patients in the event that there was reactions to the medication that were perhaps unanticipated by the patient. And so hearing those questions on Wednesday and Thursday of last week, I said from this podium, and I resolved to look into what other states had done in that regard and to see whether or not that was possible. And what I found was it is in fact possible. 3 states, 3 of the 37 states that have authorized cannabis for medical purposes utilize pharmacists in connection with the dispensing of authorized medications to patients. And so I first started by reaching out to government officials in the state of Louisiana. They had passed a law that has pharmacists in the dispensing component of the program. Spoke at length with officials there. Then spoke with the South Carolina Pharmacy Association, and they engaged in the process. They shared information in regard to if you wanted pharmacists to be involved in this process, here's how it could be done. Worked at length with Senator Cromer, Senator from Newberry, who is, as you know, a professional pharmacist, to get his input on it. Particularly thanks to my friend Senator Kimbrell from Senator Spartanburg, who really did a good job of taking the information that was received from the Louisiana officials, the South Carolina Association of Pharmacy, Senator Cromer, and quite frankly also from a group that has been historically, or not historically, the past few weeks, an opponent of this bill, the Palmetto Family Council, and I went back, and this is one of the things that I hope I've learned over the years that I've been in the state Senate from Lexington, and this wasn't always the case with me, but it is possible that sometimes I'm not entirely correct, or perhaps what I put forward can be improved, and that if you have an open mind and open ears and a willingness to engage, you can really benefit from principled opposition. And quite frankly, that's the only way you really get good legislation, is if you have principled opposition, which of course is the function of the subcommittee process and the committee process, but it continues even on the floor. And by having that principled opposition, your assumptions are challenged, or what you expect the consequences can be challenged. And then if you listen and if you engage, which is what I've done over the last 4 days, you can learn something even from foes of your bill, and you might often find them sometimes becoming allies of your bill. And I'm not going to belabor the pharmacy amendment that Senator Kimbrell is going to offer at some point in time, but I wanted to let the body know that process had taken place over the last 4 days. A lot of work I spent this weekend on this to get it ready. And really, I would make this observation. It's a reflection, or a manifestation of what I said I hoped would happen when I began this debate on Wednesday, that everybody would engage in this process, offer ideas to make this bill better. Because even though I've worked on it for 8 years and put a lot of time into it, there's the knowledge problem that Hayek talked about. You don't know everything. You can't know everything. You've got to rely upon others. And so that's an example of that. So I wanted to point that out. Now, in jumping into the mechanics of the bill, or the sections of the bill, I'm predominantly going to go chronologically, or at least in terms of order that they appear in the bill. But I think a constructive way to engage some of those sections is going to be in regard to the letter that the South Carolina Solicitors Association issued to the President of the Senate, I think it was last Thursday. This is a very productive and constructive letter that I would commend the solicitors for writing, because what the solicitors did was they talked about how they believed 150 was inadequate and that they opposed it in its current form. But it did more than that, in that it then proceeded to, with specifics, identify exactly why they opposed it, which of course provides an opportunity, such as with the Palmetto Family Council, to work on amendments or to work on things that would address those concerns. And so that's the way I'm going to start this particular process of dissecting the bill. and referring to that letter from the solicitors. The first thing they noted was they opposed 150 because there was the absence of adequate regulations necessary to deter fraudulent acts. Okay, that's a quote. The absence of adequate regulations necessary to deter fraudulent acts. Okay, and that refers to the following section of the bill, which gives me an opportunity to talk about it in a useful context. On page, let me see, line here, in section, okay, it's on section 44-53-2130 in subsection A, subparagraph 7. And that states as follows, that there must be a statement signed by the qualifying patient applicant agreeing not to divert cannabis products to anyone who is not allowed to possess cannabis products pursuant to this article, and acknowledging that the diversion of cannabis products is a felony that, upon conviction, results in the revocation of a registry identification card and subjects the qualifying patient to a fine of not more than $5,000, imprisonment of not more than 5 years, or both. So in regard to the absence of adequate regulations necessary to deter fraudulent acts, that is one thing I would point to in regard to what would currently be a misdemeanor in regard to possessing cannabis in many instances would become a felony under this law if you possess cannabis under the auspices of a medical license, but you then use it for recreational purposes. So that's one example of a deterrent that's in here. Another example would be in section 44-53-2230, subparagraph C, and that continues on to the following page into subsections D, E, and F. These are the anti-fraud provisions of the bill that the solicitors are wondering if they are strong enough. And under those particular sections, section 44-53-2230C says that notwithstanding any other criminal penalties related to unlawful possession of cannabis products for medical use, knowingly making a misrepresentation to a law enforcement official of any fact or circumstance related to the medical use of cannabis products to avoid arrest or prosecution is a misdemeanor, and upon conviction punishable by a fine of up to $1,000 in addition to any other penalties that may apply. So I think perhaps maybe the point the solicitors are making here is that the act of making a misrepresentation to a law enforcement official in regard to possession of cannabis, ostensibly for medical use, that perhaps making that a misdemeanor is not an adequate deterrent. And I think that that's something that we can explore, and perhaps we can look at through amendment. Again, I'm taking their letter in the spirit it was offered, which is how can we make this bill better? You know, they've poured through this bill. They've given very specific, lifted very specific concerns that should be taken seriously, and that's one of them. The anti-fraud provisions continue on the following page, or in that section, still on section 44-53-2230, into subparagraphs D, E, and F, and I won't belabor the point, but it makes a similar a misdemeanor out of, well, I'll just read it. Notwithstanding other criminal penalties related to the unlawful possession of cannabis products for medical use, knowingly making a misrepresentation of a medical condition to a physician or fraudulently providing material information to a physician is a misdemeanor. And again, it goes to that fraud aspect of it. In this context, the fraud contemplated would be the patient sitting down with a physician for the purpose of getting a written authorization, and that patient knowingly or misrepresenting their medical condition to the physician for the purpose of obtaining that medical cannabis card. That is a misdemeanor, and again, we can explore whether or not making it a misdemeanor is or is not an adequate deterrent. and it continues along the same lines in regard to an individual who also in regard to any qualifying patient who commits a violation or refuses to properly request a test relating to operating a mode of transportation while under the influence of cannabis. So you must have your registry card revoked if you do not cooperate with law enforcement in regard to being challenged if you're driving under the influence. If you don't produce your card, if you don't cooperate with the law enforcement, you're kicked out of the program. Again, we can talk about whether or not that is an adequate enough deterrence, but I appreciate the solicitors bringing that to my attention so that we can talk about whether or not it is. The other thing that the solicitors noted in their letter was, and I'll just read briefly, while the National Academy of Sciences reported in 2017 that there may be health benefits associated with the therapeutic use of cannabis, well, I'll stop right there. They reported there was conclusive evidence of health benefits. They didn't say there may be. They said there was conclusive evidence of health benefits, but nonetheless, continue on. There is also evidence that links cannabis with increased risk of medical conditions, of developing or aggravating other medical conditions. It then says it is not wise or responsible for government officials, rather than science and medical experts, to determine the conditions medical marijuana may be safely used for. And this is a point I want to, I addressed it with Senator Cash last week. It's important to understand that in defining the universe of qualifying conditions for which medical cannabis can be authorized by a physician, the General Assembly is not acting as a physician. The General Assembly is not acting as a pharmacist and dispensing and saying, if you have one of these conditions, you then have the right to receive medical cannabis. What we're doing in this bill, and this is fundamental to the bill, is we're empowering a physician so that a physician in inpatient consultation with the patient has the ability to authorize the use of medical cannabis to treat a condition if that physician believes it's going to be medicinally beneficial. Because simply because cancer or epilepsy or Crohn's disease or chronic pain, simply because it's listed as a qualifying condition in the bill, does not mean by any stretch of the imagination or any reading of the bill that the patient then has a right to receive medical cannabis because we listed that as a qualifying condition. All that list of qualifying conditions does is empower that physician for that physician to do what he or she believes is in the patient's best interest. That's all it does. And so I think and that misunderstanding about what we're doing here creeps into this letter by the solicitors when it says it's not wise for government officials to determine when medical marijuana should be used. We're not. We're not. We're simply empowering doctors. And as I said to the senator from Anderson last week, if I had my way, there wouldn't be any qualifying conditions constraints, and we could place sole authority for what's good for that patient in the hands of that doctor. That doctor's the one that's been to the medical school. That doctor's the one that's done an in-person diagnosis with that patient. That doctor has the ability to ask that patient questions. That's the relationship out of which the authorization of cannabis use comes, not by this General Assembly, okay? But I recognize that there is some trepidation about treating cannabis as medicine and the potential for abuses. And so that's the reason why there's a constraint on the authority we're giving to physicians. Because of that doubt, because we don't know exactly how this is going to work. But don't infer from that, don't infer from the fact that we list qualifying conditions that we're somehow acting as doctors here or we're acting as pharmacists here. We're not. We're simply empowering a physician. And I think that's a critically important point to make. Another concern expressed by the solicitors was in regard to impaired driving and the lack of there being the equivalent of a blood alcohol content test that could be given to somebody who was driving under the influence of cannabis. And they reached the conclusion that law enforcement and prosecutors will not be able to arrest and successfully prosecute impaired drivers with THC in their blood. And needless deaths and prevent needless deaths on our roadways. Well, that's true in regard to there isn't a test for THC that is as reliable as the test for blood alcohol content that's currently when you use a breathalyzer. That's true. But it is not true that in the absence of such a test that you cannot arrest and successfully prosecute somebody for driving under the influence, because there are field sobriety tests, there are standards of engagement in regard to when somebody is driving impaired under the influence of marijuana. There are things you look for. There are protocols that have been developed in other states. There is guidance for our law enforcement when they're out there trying to make that determination. So I would just point out that that's the same problem they arise in regard to some other prescription drugs that may be in somebody's system. And it's hard, you don't have a blood alcohol content equivalent to detect those drugs, and yet opioids are legal and other prescription drugs are legal. And so I would submit that the fact that there isn't that level of testing in regard to cannabis is not a reason for opposing this bill. And again, and I know I'm going to have a disagreement with some of my friends in opposition on this bill, but I've come prepared with 5 peer-reviewed studies over a period of 25 years that, again, show that there is a direct correlation between states that have medical cannabis laws and an overall decrease in traffic fatalities, because marijuana and alcohol operate primarily as substitute goods, okay, not complementary so much, but substitute goods. And this is demonstrable not only across a number of states, but also by the Federal Department of Transportation. And I'm going to make that information available to this body, because it's simply not true to say that in the event you establish a medical cannabis law, you're going to see incidences of impairment go up and fatalities go up. The data and trend lines in these comprehensive studies show the exact opposite. The next section of the bill that the solicitor's letter invites me to talk with you about, it says that S150 fails to provide restrictions on the form cannabis products may be made available and distributed. In keeping with the bill's focus on cannabis use for medical purposes, the sale of cannabis should be heavily regulated to define allowable products, with restrictions regarding cannabis plant material, edibles, and new products are developed in the future. Access to and packaging, storage, and display of allowable cannabis products must also be regulated to adequately provide notice and caution of various risks, including accidental consumption or use by young children. Other states have banned many types of edibles due to their attraction to children. Okay, so in addressing that, we have a chance to look at the bill, and I can talk about some of the sections here. First, in response to that expressed concern, I would go to section, this is the definitional section of the bill, which is section 44-53-2010, which defines various terms. And looking at subparagraph 14, it says that it defines exit packaging, which later in the bill says this is how cannabis product must be dispensed to patients. That means, quote, a sealed, child-resistant packaging receptacle into which prepackaged cannabis products are placed at the retail point of sale at a dispensary. So that's one instance in which we do regulate in regard to packaging. Another example, again, turning to the bill, and again, I won't go over these sections again. As I chop them off here, I'll make a note. Line 14, this is in section 44-53-2350, subparagraph A, subparagraph I, subparagraph tiny I. And this is setting forth various regulations that are to be issued by DHEC. Requirements that the medical cannabis establishment's logo, advertising, and signage be tasteful, respectful, and medically focused, and must not appeal to minors or contain cartoon-like figures or attempts at humor. Requirements that medical cannabis establishments submit any logo or sign for review to the department in accordance with department regulations. Prohibitions on medical cannabis establishments from using marijuana leaves or slang for cannabis or cannabis products in or on their signs, logos, packaging, or structures. And then limitations on the size and location of signs and prohibitions against using neon-colored signage, logos, and packaging, or neon-colored signage or logos or structures. So when the solicitor's letter talks about there not being regulations in regard to the packaging, storage, and display of cannabis products, I would look to those particular sections of the bill. And again, I'm open to the idea of making those provisions better, but it's worth noting that the bill does do exactly the sort of things that the solicitor's letter rightly says it should do. It does regulate and provide restrictions regarding plant material, edibles, and products. It does provide restrictions regard to packaging, storage, and display. It does talk about how it's marketed. It does talk about child-resistant packaging. It does talk about those things. Now, having said that, I'm open to and I'm engaging with the solicitors in how we can make it better. Again, I take this as I took the Palmetto Family Council's comments. I take it as constructive criticism and as an attempt to make the bill better. And I'm taking this bill or this letter that's being submitted here with that same spirit. The next thing the solicitor's letter notes is that before a bill with such risks and potential negative impact is enacted, the legislature must be sure that DHEC has a viable plan for developing a new program that minimizes these risks and that the appropriate funding is available. So in that regard, the next section of the bill that I would like to explain is section 44-53-220, subparagraph A, which talks initially about the funding for DHEC to administer the program, the concern that the solicitors are expressing here. It states that the department, meaning DHEC, shall establish a South Carolina Medical Cannabis Program Fund to ensure the availability of funds necessary to carry out the department's responsibilities under this article. All monies collected pursuant to this article must be deposited into the fund. The fund must be used for direct and indirect costs associated with the implementation, administration, and enforcement of this article. The next, turning to the next section, section 44-53-2030, it states as follows: notwithstanding any other provision of the law, the department, again meaning DHEC, may implement a reasonable fee increase to be charged and collected pursuant to this article if necessary for the department to cover the cost of administrating and operating the program pursuant to this article. And then immediately following that in the next section, section 44-53-2040A, it then says that all sales of medical cannabis products are subject to a 6% sales tax at the point of sale. So now turning back to the solicitor's letter and stating that we need to be sure that DHEC has the appropriate funding, I will represent to this body that in well, I can't say the 37 states because Mississippi has just started their program, but in the 36 states that have medical cannabis programs, they operate over time using fees and revenues derived from that particular program. They don't rely on the general fund in the long term. Now, what I will say to you is that initially, when we're initially setting up DHEC's protocols and registries and things of that nature, and if SLED, needs to have, some FTEs, there may be some initial general fund impacts in regard to establishing this program. But I represent to you that over time, it not only covers the cost of administering the program, it is a revenue generator, okay? And I've never positioned this bill or argued for this bill in the context of it being a revenue generator, because I've always been careful to constrain the fees and the taxes to those being what is necessary to cover the cost of administering the program, because medical cannabis is going to be something that patients have to pay for out of pocket. It's not covered by insurance, and it's not my desire to drive up the price and keep medicine out of people's hands. But when I'm confronted by a statement that says that the bill doesn't provide adequate funding and that DHEC is not going to have the resources necessary to implement the program, I do need to push back. That is not what the experience in the other states that have legalized medical cannabis have had. And aside from the initial general fund impact, which I acknowledge is going to be there until you get protocols in place and cards issued and physicians' authorizations given and actual cannabis purchased, you're not going to have the revenue streams initially that you're going to have subsequently. But I did want to point out those sections of the bill that do provide for funding, fees, and a sales tax. The last concern that they have is in regard to the following section of the bill, which is section 44-53-2390, subparagraph I. And this relates to, and this is the criticism or objection offered by the solicitors, the bill should apply the same lifetime prohibition to marijuana establishments as it does to other medical facilities and establishments. What they're talking about is that this bill prohibits an individual that has been charged with a felony drug charge from working or receiving a license to operate an establishment that sells marijuana for 5 years. Yet under our current law, individuals with a felony drug charge cannot ever work in a pharmacy or doctor's office, even after 5 years. So their concern is that this disqualification in the section I just cited to you says that you can serve in a medical cannabis establishment, even if you've had a felony, if that had occurred at least 5 years prior. What they're saying is they want it to be a lifetime ban. If it is the opinion of this body, of this Senate, that it is important to have a lifetime ban on an individual who has a felony for a drug-related offense from ever working in or owning a medical cannabis establishment, again, I take this letter as constructive, and when we can have that discussion. And finally, I want to conclude by this particular part of describing the bill by, complimenting the solicitors on how they closed the letter. It said, "We recognize the hard work and thoughtful intent of the bill's drafters, and we are happy to assist the legislature." So they're not only looking at the bill, expressing specific concerns, they are saying we are willing to sit down and work with the legislature in addressing those concerns. And that is what I am doing. And so I wanted to take that opportunity to go through the solicitor's letter. And that would give me an opportunity not only to talk about what I think is a constructive process, but also start to tackle some of these sections of the bill in a context in which maybe it would have meaning other than if I was just rolling through it chronologically. But then turning back now to where I think we are in the bill in terms of what we haven't covered yet, I do think we've gone through section 44-53-2080 that talks about the written certification form that a physician must issue before he or she can authorize cannabis use by a patient. And I don't want to plow that ground again, but I would point out to you that section 44-53-2080 sets forth some very high bars that the physician has to cross in order to authorize the use of medical cannabis. And it relates to a number of things ranging from, the treatment history and what the patient has tried in the past and finding out what the patient's history of alcohol and substance abuse has been, whether or not they've had a history of mental illness or psychiatric disorders. I mean, I'll just suffice to say it's an exhaustive list of things that the physician has to do before he can authorize or she can authorize cannabis for use by a patient for a specific qualifying condition. And that's important because in a lot of states, what I found in investigating them is a lot of times it's simply a cursory review by physicians, or a patient can just drive by to somebody in an office, step in, get a written certification, and then that patient goes out and gets the cannabis.
Senator from Charleston, Senator Gibson, what purpose do you rise?
Question?
Yeah, for a brief question, yes.
Okay.
Senator, yes, for a question.
Senator, I didn't want to interrupt you, but did you know I looked at that list of physician certification requirements, essentially. And it's a pretty exhaustive list. The question I would have is, who wants to certify all of that? I mean, have you floated that by the people, the proponents? And there are significant, despite this medical association letter, there are a number of doctors who are endorsing your bill. Did you know that?
Yeah, there are, Senator from Charleston, and that's a good point in that, and first of all, you're right that this creates an exhaustive and thorough review by a physician. And again, that was intentional because this bill is physician-centric. We're putting so much confidence in our physicians in terms of authorizing the medical cannabis use that at least initially, when we're first starting out in this and before we have a substantial history of what the experience has been, I wanted to be very proscriptive in regard to the things that we're looking for that physician to do. And that goes back to the point I made a little bit earlier. We as a General Assembly are not acting as doctors. We're not prescribing medication. We're not saying that this is what a cancer patient should have, this is what an epilepsy patient should have. What we're doing is empowering doctors and then ultimately relying upon that doctor's judgment.
In this piece of legislation, we're not acting, because we act as doctors in a lot of other scenarios. I just wanted to make that comment.
But to your point, there are physicians in South Carolina that assisted in the drafting of this. And in fact, the South Carolina Medical Association was involved in drafting those lists of conditions and that was very helpful to get their input on that because they were able to tell me, okay, this is what a bona fide physician-patient relationship looks like. This is what, if you want a physician to make an informed decision about whether a patient can benefit from medical cannabis, these are the sort of questions that need to be asked. These are the sort of things that he or she needs to consider. So they did a very good job of helping me come up with those lists of standards. And it is a high bar, but in working through this process the last 7 or 8 years, there are physicians out there that want this option and that are ready and willing to engage in this option.
And Senator, did you know, I just wanted to make sure that there was a pool out there to get these prescriptions written by doctors after all of the acknowledgments that are prescriptive in the bill. You've done a fine job incorporating those components. Just want to make sure that we can get the prescriptions out to the people who need it. Did you know that?
Yes, sir. Thank you, Mr. Senator Charleston.
Senator from Anderson, Senator Cash, what purpose do you rise?
Senator Yields.
Senator, I know
Senator
you're
Yield
trying
for
to
a
get
question.
through. Yes, would you yield for a question?
Absolutely. Absolutely.
Senator Yields.
Senator, I know you're trying to get through this bill, and it's going to be 2 o'clock soon. So if you want to keep explaining, that's fine, but I've got a series of questions. I've spent quite a bit of time reading and studying the bill, and it's kind of your choice, but I'd be happy to ask the questions now.
Let me do this. Let me go through right now and make an expedited effort to really get through the bill quickly, because I know a lot of you now had a chance to read it for yourselves, and you don't need me to read it to you. But I'll move very, very quickly, maybe 15, 20 minutes, and then yield for some questions.
Thank you.
That's it.
Senator from Clarendon, what purpose do you rise?
Thank you. Mr. President, I heard what the senator from Beaufort just said, but I was wondering if he would yield for just maybe a couple of questions based on your interchange with the senator from Charleston,
yes.
Senator Kempson.
Yes.
And I think in one of your responses...
Senator Yields.
Thank you, Mr. President. Thank you.
Senator Yields.
I think in one of your responses to Senator Kempson's question, you mentioned that the South Carolina Medical Association helped draft this legislation, or what did you say about the South Carolina Medical Association?
In connection with this bill and in working on this bill over time, there are various groups that have opposed the bill. Law enforcement, Palmetto Family Council, South Carolina Medical Association, solicitors. My point there was that, like with the solicitors, the South Carolina Medical Association didn't stop with, we just don't like the bill. They actually sat down with me and went through the bill and helped me and educated me as to, if you're going to have a process whereby a physician does an examination of a patient and ultimately gets to a point when they're going to certify whether medical cannabis can be beneficial, these are the sorts of things that a physician would do in order to reach a medically reasonable decision. And so they helped with the language. I don't mean to imply by that they became a supporter of the bill, Senator Johnson, Senator McLaren, excuse me.
Yes.
What I'm saying is that's another example of constructive engagement by a stakeholder group that had concerns about the bill. That was my point.
Okay, good. I'm glad you clarified that, did you know, because I didn't want to confuse anybody to make them think that the South Carolina Medical Association was in favor of the bill.
No.
And I think I'm correct, am I not, that they are against the bill, as is the American Academy of Pediatrics, the American Medical Association, the South Carolina Pediatrician Association. So these medical associations, I think I'm correct, in addition to the South Carolina Medical Association, are in opposition of this bill. Am I correct?
Well, if you want to go through a list of the groups that are for or against, I can do that. It's going to take me off my...
No, don't. I just want to know. You actually answered my question, because when you responded to him, I thought that it may have been misconstrued that the SCMA was in favor of the bill. And I think you responded to my question that they just sat down and just kind of gave you some input as far as what they thought would make the bill better, but not that they were in favor of the bill. And I didn't want anybody to think that to misconstrue your comments as them being in favor of this piece of legislation. So you actually answered my question, and I appreciate it.
If I said that, I misspoke. I don't think I said that.
You didn't. I just wanted to make sure that we clarify that so nobody else would get that impression, but I appreciate you responding to my question.
Let me finish this thought before it escapes me. Those associations in favor would include the American Academy of HIV Medicine, the American College of Physicians, the American Nurses Association. I've got about 15 other groups as well. So, but this really isn't about, lining up associations like it's a football game and see who can bowl over one or the other. I think it's fair to say that different groups and different individuals have different views on the use of medical cannabis in a medical context at this point in time. I guess my point would be not that there isn't reason to oppose the use of medical marijuana. You can make, and we're going to hear from opponents of the bill, examples of instances where marijuana can't help with cancer, or marijuana doesn't help with chronic pain, or marijuana can lead to the exacerbation of psychic disorders, or marijuana can do other negative things. And my point to that is, all that's true. I'm not holding marijuana out there as some sort of panacea that can solve every medical ill under the sun. What I am saying is it is an important tool and option to give physicians in order for that physician to determine, and sitting down right across in that very personal relationship with a patient, giving that physician that option if that physician believes it can help that patient. So I'm not going to say marijuana doesn't have negative consequences. I'm not going to say it has uses in all those qualifying conditions. Different people are going to respond in different ways. I guess my point is we need to go ahead and get out of the way as much as possible from that physician sitting down with that patient and those two individuals deciding, what that patient is going to take to improve their life. And I guess my point would be, it's not the proper role of the state. It's not the proper role of law enforcement. It's not the proper role of the religious community to step into and interfere with that relationship between a physician and patient. I mean, to me, that's basic. And so, no, marijuana is not perfect. Yes, people can have adverse consequences to marijuana. That's why we have such a detailed requirement in regard to what that physician has to do before he or she authorizes a patient to take it.
Thank you, Senator. And the comment you made a while ago about people not interfering with the medical doctor and his patient was an argument I made on another bill. But since you brought it up, I think the bill, or there is an impression or an assumption that medical marijuana helps with cancer. I don't know if it does or it doesn't, do you know? But I do know that the American Cancer Society's position is that it does not.
Let me be clear about what I mean when I say cancer, okay? Because the studies that I have, the peer-reviewed studies that I have saying it could be medicinally efficacious is in regard to the aftermath of chemotherapy, in terms of stimulating appetite, in terms of addressing nausea, in terms of addressing chronic pain. So I would agree with you in terms of the cancer itself, which is what you're referring to. There's not the peer-reviewed evidence that it can kind of abate cancer or cause it to go into remission. What I was referring to is, and this was the case with Bill Herb Kurzman's brother who died of cancer The only thing that kept him going and stimulated his appetite and got rid of the nausea was marijuana. And so and when I talk about cancer, it's in that context, not the curing of cancer.
So are you saying that was the only thing that kept him going was medical marijuana?
In terms of his quality of life, in terms of his ability to enjoy life in the months that he had after having kidney cancer, you can talk to Representative Herb Kurzman about that, but that is my understanding.
Okay. So one of the other illnesses that's on the list, I think I read in this bill, is glaucoma. And were you aware that that the American let me get this right, Ophthalmological Society disagree with that as far as whether marijuana helps with glaucoma?
And that's a fair point. And one of the amendments that I'm putting up, because I went back through Senator Johnson, Senator Clarendon, in looking at this bill, and you're right in regard to glaucoma, because even though it does have the effect of relieving pressure on the eye, which of course is something that can mitigate glaucoma, there are prescription drugs that are efficacious in that respect to the degree that marijuana is not. And so even though, again, for purposes of if it were my preference, we'd let a doctor do whatever he or she thought was in that patient's best interest. But I recognize that what we're doing here is that we're defining a set of conditions and providing some guidance initially, empowering doctor only in a limited way. And I say to that, what I was going to do is look at the conditions for which there is substantial peer-reviewed study that shows it can be helpful. I agree with you that glaucoma does not reach that level. And that's why I have an amendment on the desk that takes that out as a qualifying condition.
Now, one more, and I'll take my seat, because I know you want to finish your presentation.
Fine. This is helpful. This is good.
Another condition that I think I saw in the bill that medical marijuana is supposed to help with deals, I think, with psychiatric or either mental issues. Are you aware that the American Psychiatric Association said this about medical marijuana? It says medical marijuana for the treatment of psychiatric problems is no better than providing cigarette smoke to cure lung cancer or lung disease.
But that's not one of the qualifying conditions, Senator.
Okay.
I mean, again, let's just go through them since I'm at the section now anyway. It's the definition of debilitating medical condition. That's in section, the very first section, 44-53-2010, subparagraph 8. Cancer. And again, I qualified by my answer there about cancer, multiple sclerosis, neurological disease or disorder, including epilepsy, glaucoma, we talked about glaucoma, post-traumatic stress disorder, Crohn's disease, sickle cell anemia, ulcerative colitis, wasting syndrome, autism, severe or persistent nausea, a chronic medical condition causing severe and persistent muscle spasms, and any chronic or debilitating disease or medical condition for which an opioid is currently prescribed. So that's the universe of conditions and doesn't include the sort of thing that you're referring to there.
Well, Senator, I thank you. I have some more questions, but as I said, I don't want to interrupt your presentation, so I'll save those for another time. Thank you.
But again, that was very constructive. Thank you. Okay, section 44-53-2110 of the bill talks about what the department does in regard to issuing registry identification cards to patients, and it talks about the information that's contained: name, address, date of birth, date of issuance, a random alphanumeric identification number, photograph, just technical things in regard to what the department will do in establishing a registry identification card that can be possessed by a patient who has qualified to receive cannabis for medicinal purposes. Section 44-53-2120 talks about reciprocity, I guess. It talks about in terms of a valid registration, a registry identification card or its equivalent that is issued pursuant to the laws of another state, and talks about the circumstances in which that recognition is recognized. That's going to be addressed, I think, in the Senator from Spartanburg's pharmacy amendment, essentially to modify or curtail that so as to, as I understand it, constrain it to this program to those that are issued in South Carolina. But I'll let the Senator from Spartanburg talk about that when it's time for his amendment to be discussed. Also talks in that same section, in subsection B, giving registry identification cards to designated caregivers and setting forth the qualification for being a caregiver. And of course, that means what it implies, which is an individual who could stand in the stead of a patient and receive and go to the dispensary or a pharmacist and get the medical cannabis. This relates obviously to situations where you're either dealing with a minor or you're dealing with a patient who is homebound and is not ambulatory and can't get to the dispensary or to the pharmacist, him or herself. But that section deals with how do you become qualified to become a designated caregiver, and how does the department evidence that somebody is authorized to be a designated caregiver. Section 44-53-2140, again, it starts out by saying, under what circumstances can a department issue a registry identification card to a person? And it starts with the very fact a physician has to submit that written certification to the department that certifies that the person has got a qualifying condition. And again, this emphasizes that nothing happens, no cards are issued, no cannabis is purchased by a patient until that physician, in a written certification, after going through an exhaustive list of what he has to do or she has to do to examine, certifies that this patient has a qualifying condition and that they could benefit from medical cannabis. They also see further provisions there in regard to conditions precedent to a department issuing a registry identification card. One thing I would point out in that same section, 44-53-2140, subparagraph C, and this is something that I was talking with my friend, Senator from Charleston, Senator Sen, the other day about. It reads as follows. For a new patient applicant not to include a renewal, the department may not issue a registry identification card to a patient applicant who is between the ages of 18 and 23 years unless two physicians who have performed in-person exams and verified the patient applicant's debilitating medical condition submits a written certification to the department on behalf of the patient applicant. And the Senator from Charleston, Senator Sen, raised some good questions last week in regard to, is that violative of the Equal Protection Clause? And my response was that it is not violative of the Equal Protection Clause because individuals aged 18 to 23 are not a suspect class as defined by the Supreme Court of the United States. Therefore, this particular provision doesn't have to withhold or bear up under strict scrutiny. It only has to bear up under the rational basis test. In other words, is there a rational basis that serves a legitimate state objective in treating this class of individuals differently? And I think that this particular provision does meet that lowest standard of review under equal protection by satisfying that rational basis test, because I think that if you're 18 to 23 years old, given your terms of development, given your degree of maturity, I think that there's a rational case to be made for the fact that as to that class of individuals, two written certifications is a burden that is not unreasonable. Now, that's something that we can debate, and if others think that this is too much of a burden or do think that it's violative of equal protection, willing to look at an amendment and take that up. But I can tell you that based on my analysis of this, not a suspect class, rational basis test applies. There is a legitimate government objective here, and I think this is a rational way of achieving it. So that's my little argument there. All right, section 44-53-2150 talks about designated caregivers can only serve one patient unless the caregiver is a facility licensed by the department. And what's meant there is, I guess, is some sort of a group home or a nursing home or some sort of facility where there may be numerous individuals who qualify or have medical cannabis cards or authorized to receive medical cannabis by their physician. In that context, a facility could have more than one patient. In other words, they could operate and act on behalf of the various individuals in the facility.
Senator from Charleston, Senator Kempson, what purpose do you rise?
Unanimous consent motion.
Request, state your request.
just to make an announcement with the senator holding the floor, I wanted to just make an announcement.
So you're recognized to make an announcement.
Wanted to let
without objection.
Want to let the colleagues know that Robert Bochez is out in the lobby. This is the governor's nominee for the chair of DHEC. So if you have any questions, he'll be out in the lobby. Like you to meet him. Thank you.
Senator so notified. Senator from Beaufort.
The next section is section 44-53-2170, which says, until 90 days after the department begins accepting applications for registry identification cards, a copy of a patient's valid written certification issued and printed by the physician on tamper-resistant paper within the previous year must be deemed a registry identification card for the qualifying patient. In other words, while the department's in the process of putting into place its system of issuing registry cards, with those cards evidencing one's right to obtain medical cannabis from a pharmacist or dispensary. Until that system is up and running, the written authorization signed by the physician serves as that registry identification card for that gap period while that's being developed by DHEC. Section 44-53-2180 states that a qualifying patient must notify the department of any change in his name, address, telephone number, or email address, or if he ceases to have a debilitating medical condition. So this goes to the strict monitoring of this program, in that DHEC records, which are fully accessible by SLED pursuant to this bill, have to have accurate information in regard to that qualifying patient, in regard to where they're living, how they can be contacted, what their telephone number is, what their email address is. So there's a burden on the part of the qualifying patient to make sure that the department has up-to-date information as to their whereabouts. And again, if this is violated, the penalty is a revocation of that registry card. And let me just make this one point. A lot of these nuts and bolts and mechanics and how the system would work, I would say two things. First of all, I had the advantage of looking at the 36 other states that had medical cannabis laws and looking at what they did in terms of setting up a program, and then inquiring of officials in those states, as I have, what's worked? Did they ever have to amend something? Was there something that was provided for that had an unintended consequence? So this bill and all these nuts and bolts are a product of those inquiries on my behalf and the subcommittee's behalf. They're also, what's in here is the product of what DHEC said it wanted. This is laid out. DHEC had carte blanche. I said to DHEC, I want you to come up with language that if the General Assembly decides it wants to empower physicians to authorize use of cannabis by patients for certain conditions, what would the program look like? How would you tell me how it could be set up in a way that enables you to effectively administer the program. Every single thing that DHEC requested is in this document. There's nothing in this document that DHEC suggested should be done that isn't in here. So I want to make that point, that on the front end, and this was several years ago, but it continued over time, DHEC was continuously engaged in their ideas solicited, and what they proposed incorporated into this bill. Section 44-53-2190 talks about DHEC's obligation to establish a secure web-based verification system. It talks about what the verification system must contain. Section 44-53-2195 makes it clear that medical cannabis product information received and maintained by the department is confidential and is not subject to public disclosure under the Freedom of Information Act. Again, this is a confidential list and cannot be accessed by the public. You've got various healthcare privacy concerns associated there. Section 44-53-2200 talks about the cannabis products that a patient can be authorized to get can only be in 14-day increments. Again, that's more conservative than in a lot of other states. For instance, Mississippi, who passed their law last week, again, by a 10-to-1 margin in the House and the Senate, allows for a 30-day, I believe, 30-day authorization, and the Mississippi bill allows flower to be smoked. I mean, and the Mississippi bill has 24 conditions, not 12. So it's more liberal in those respects than our law, but this is our law, okay? And our law limits the amount that a patient can get at any one time to a 2-week supply of cannabis. Section 44-53-2210 creates various safe harbors that if you are a qualifying patient who has been issued a registry card by DHEC, or if you're a designated caregiver that has been properly issued a registry card by DHEC, that those individuals, the patient and the designated caregiver, cannot be then arrested for possession of medical cannabis if that medical cannabis has been authorized by a doctor and is in that 2-week amount, allowable amount, and if it's not, well, anyway, it's a safe harbor, saying it's not illegal for them to possess medical cannabis under those circumstances. If you have a card, you've been authorized to have it. Section 44-53-2220 states that it is unlawful for a physician to certify cannabis products to any person for the purpose of smoking or burning. And then the next subparagraph says it is unlawful for a cardholder to possess cannabis in plant form or to smoke cannabis or use a device to facilitate the smoking of cannabis. And again, this is a concession that was made to law enforcement, I want to say a couple years ago, when I asked SLED and law enforcement what their concerns were about this bill. In fact, Margie Bratt-Matthews, senator from Colleton, was the one who interacted with them. And the number one thing, the concern they had was they did not want individuals to be smoking or burning leaf to consume medical cannabis. And so that was incorporated into the bill to make it unlawful to smoke marijuana. Section 44-53-2230, this will be of interest to those who are concerned about how can law enforcement hold to account somebody who is operating a motor vehicle while impaired by cannabis. And this particular section, talks about, first of all, in that section 44-53-2230, paragraph A, subparagraph 1, it says that an individual cannot undertake any task under the influence of cannabis if doing so would constitute negligence or professional malpractice. In other words, there is no safe harbor here for doing things if you have a medical cannabis card. You can still be negligent. You can still commit malpractice. Those same rules in regard to what a prudent person in reasonable actions in ordinary circumstances, those negligence principles still obtain. There's no special harbor created for those that are taking cannabis even legally under this program. Also states that an individual cannot operate, navigate, or be in physical control of any motor vehicle, aircraft, train, or motorboat while under the influence of cannabis. So again, this particular section is going to be of interest to those of you who want to dig into have we done enough to enable law enforcement to hold to account individuals who operate vehicles illegally under the influence of cannabis. And so that's the section you may want to direct amendments to if you have concerns in that regard.
Senator from Newberry. Senator,
Mr. President, I want to see if the senator would yield for one question.
Senator yields.
Senator, I'm sorry to interrupt you. I've been sitting over here trying to keep my mouth shut. But I wondered how you would determine if a person is under the effects of a particular drug, let's say cannabis. Is it got to be a certain amount in the bloodstream, or?
We had a talk about that last week. Senator Sin, in particular, Senator from Charleston, and she rightly pointed out that there is currently not the sort of means like we do with blood alcohol content, where you can do a breathalyzer, and if you blow a 0.08 or above, then you're presumed to have been operating under the influence of alcohol, or that's a presumed matter of law. There is not a similar thing with cannabis. Now, you can do blood tests, and those blood tests will detect whether or not you have THC or the psychoactive component of marijuana in your system. But the problem is, and again, this is what I've learned about this, is that marijuana or THC can remain in your system for a long period of time, so you can't necessarily draw the same inference from the presence of THC in regard to operating impaired that you can with the blood alcohol content. Okay, it just interacts with the body differently. And so the discussion we had last week, and I frankly acknowledge that what we're talking about here in terms of law enforcement being able to hold individuals to account who operate vehicles under the influence of cannabis is going to rely heavily on roadside sobriety tests and the sorts of things. But what I will say is, we've had states with decades of experience in regard to this now. And so there is a lot of experience and knowledge that can be shared with law enforcement as to how do individuals who are impaired by cannabis exhibit that impairment. What sort of things do you look for in terms of coordination or in terms of things that are the tells? But anyway, I just wanted to draw attention to that section, 44, 53,
Thank you, and
220.
I'm sorry I wasn't here to hear you last week.
No. Section 44-53-2230, for those of you who are especially concerned about that aspect of this and how do we put law enforcement in the best position to detect and hold individuals driving impaired to account.
Senator, I guess you could maybe take a small hair sample, which is where it remains the longest, I believe, if I'm not mistaken. And a president up there is rubbing his head like maybe you don't have a chance for a hair sample or whatever.
Section 44-53-2240 of the bill talks about DHAC denying, revoking, or suspending the registry identification card of a qualifying patient or a designated caregiver if they do not comply with the provisions of this bill. If they violate any of the restrictions that I'm going through here, the penalty is revocation, and you can't participate in the program any longer. Section 44-53-2250 talks about, let me see, if law enforcement has probable cause to believe that cannabis products are possessed at a specific address in violation of South Carolina law, then the officer may verify whether the address is associated with a qualifying patient, designated caregiver, or medical cannabis establishment through the Department's verification system. Okay, so that is meant to give law enforcement access to this DHAC registry database so that if law enforcement believes an individual may be in possession of cannabis for whatever reason, if they have probable cause to think so, that they have the ability to go into DHAC's registry to see whether or not that individual is a member of the program, because of course that may inform the law enforcement as to whether or not they want to go ahead and confront the individual or ask the individual about why he's possessing cannabis. It gives SLED the ability to access that database for that particular information. Whether somebody that they suspect of having cannabis, they can check DHAC's records to see whether or not that person is a registered cardholder. And that's section, I'm sorry, I don't know if I said it, section 44-53-2250. Section 44-53-2260 is what I kind of refer to in my own head as the Chamber of Commerce section. One of the things that I did over the years in working on this bill, again, as I say, I worked with various stakeholders, worked with law enforcement, worked with the faith community, worked with DHAC, worked with, the medical community. I also worked with the business community and the Chamber of Commerce and said, okay, look at this bill and provide me with your feedback on it. And this is what they wanted in there. This subparagraph I'm about to read to you, subparagraph C, in that section 44-53-2260. Nothing in this article requires an employer to make any accommodation for the use of medical cannabis products on the property or premises of any place of employment, to allow the ingestion of cannabis products in any workplace, or to allow any employee to work while under the influence of medical cannabis products. This article in no way limits an employer's ability to discipline or terminate an employee for being under the influence of medical cannabis products in the workplace or for working while under the influence of medical cannabis products. So, in other words, the right to access cannabis to address your medical condition. If you have a card, if the physician authorizes it, if you have a debilitating medical condition, that does not trump the right of an employer to dictate what that workplace environment is going to be. Okay, that's what this particular section of the bill stands for that proposition. I think Senator Rice, Senator from Pickens, asked this question further in that section 44-53-2260. Says, subsection F says, nothing in this article requires a motor carrier or private carrier as defined in section 5823.1110 to make any accommodation for the use of cannabis products by any employee whose duties affect the safety or operation of motor vehicles in transportation on public roads. That was added in there at the request of the Trucking Association. They wanted to make certain that they, again, similar to other employers controlling their workplace, the truckers wanted to have that degree of control in regard to their employees. Section 44-53-2265, again, reiterates, this article does not affect the ability of a private employer to enforce a drug-free workplace policy or zero-tolerance drug testing policy prohibiting any applicant or employee from having a detectable amount of marijuana metabolites in the applicant or employee system. Again, this is all part of my conversation with the Chamber of Commerce. Section 44-53-2270 says that a person who is employed by or has contracted with the state of South Carolina is not subject to arrest by law enforcement if they have a medical cannabis card. So in other words, contracting with the state or being employed by the state is not a prohibition against you using medical cannabis. So I guess you could look at it in a way as being a carve-out to that general rule in regard to the workplace. I have said in regard to the state that if you're an employee of the state or someone who contracts with the state, that you cannot be precluded from having a medical cannabis card and having cannabis as medicine if a physician authorizes it. Again, this is something that we can discuss if the body doesn't think that's appropriate, but again, I'm going through the bill and telling you what it says at this point in time. Section 44-53-2280 talks about a school or a landlord. No school or landlord may refuse to enroll, lease to, or otherwise penalize a person solely for the person's status as a cardholder, unless failing to do so would violate federal law regulations or cause the school or landlord to use a monetary or licensing-related benefit under federal law. Again, understanding that in some cases you're going to have, federal funds or federal involvement. And again, this is still a Schedule I drug under federal law, so not wanting to put the landlord or the school in a position of jeopardizing those federal funds. Section 44-53-2290 states that this is in regard to a standard of care. And again, this goes to the conversation I had with the senator from Charleston, Senator Senn, last week. A physician may not be sued for medical malpractice as a result of certifying a qualified patient's medical use of a cannabis product in accordance with this article. However, the immunities provided by this section shall not be construed to prevent a physician from being penalized or sued for violating the standard of care or for any violations of this article, including certifying a person for medical cannabis products who does not have a debilitating medical condition. So, in other words, a physician is subject to the same malpractice standards, the same standard of care, that there's no safe harbor created, but by the same token, the mere fact of authorizing medical cannabis for use by a patient is not prima facie evidence of negligence. But again, that particular prohibition against a prima facie presumption that somebody is acting negligently by authorizing medical cannabis, that is then qualified by saying the physician still has to exercise due care in connection with authorizing the use of cannabis or otherwise providing care to a patient who is accessing medical cannabis. Section 44-53-2300 provides various information in regard to financial institutions that accept the deposit of proceeds from medical cannabis establishments. I talked a little bit in the past about the guidance that's been given in that regard by the FinCEN division of the Department of Treasury, that there's a laundry list of things that credit unions and banks need to do in order to avoid penalties or fines. Again, a large part of this whole banking piece of it is going to be driven by those guidelines given by the federal government. And this just gives me another opportunity to sort of reiterate what I said when I first began this discussion way back last Wednesday. The federal government has accepted this is happening. It has green-lighted this. Every year in the budget, it passes a rider that says the Department of Justice can't use any funds to interfere with states that have medical cannabis laws. The IRS issues formal recommendations and guidance to medical cannabis establishments on how to file their taxes. The Department of Treasury, again, has those particular guidelines given to financial institutions. You've got the Department of Treasury also has certain guidelines in regard, Department of Justice, excuse me, in regard to the Hart-Scott-Rodino Antitrust Act. How can medical cannabis establishments comply with federal antitrust law? So at various levels of federal government, you've got the federal government, either authorizing or giving a green light to states in the budget, or you've got agencies, the IRS, the Department of Justice, all issuing regulations and guidance to facilitate those who are operating in state-authorized medical cannabis programs. Section 44-532310 talks about a person is not subject to arrest by being in the vicinity of a qualifying patient engaged in the medicinal use of cannabis products. Section 44-532320 states that the lawful use of medical cannabis products pursuant to this article should not be used as a relevant factor of evidence in proceedings regarding parental rights, child welfare, guardianship, decision-making, or probate matters. However, it says that this section should not be construed to allow a person to engage in conduct that would be negligent to undertake while impaired by cannabis. So, in other words, on its face, an individual's use of medical cannabis that is legal is not evidence of whether or not that individual is fit to be a custodial parent. However, by the same token, that cannot be construed to allow the person to engage in any conduct that would be negligent. So it's similar to what we talked about earlier in regard to malpractice. The mere fact of a physician authorizing the use of medical cannabis is not indicia of malpractice. However, that physician is still subject to the same standard of care. Same thing here. A person's qualification to take medical cannabis in a custody context is not an immediate disqualification for being the proper parent to have custody. However, neither is it a safe harbor, and that person still cannot engage in conduct that would be negligent to undertake. So that's that section. Section 44-532030 talks about for the purpose of medical care, including organ and tissue transplants, a qualifying patient's use of cannabis products, according to this article, is considered the equivalent of the authorized use of any other medication used at the discretion of a physician, okay, and does not violate the use of an illicit substance law. Section 44-532340 again sets forth, this now sets forth individuals that will serve on a commission, okay? And this commission will subsequently be charged with, over time, looking at how the science of cannabis and medical conditions evolves over time, and subject to petitions and evidentiary requirements and a majority vote, can authorize further qualifying conditions. In other words, further empowering a doctor in those circumstances where he or she believes that medical cannabis can be efficacious. It sets forth who the members of that commission are. the DHEC director, the director of LLR, the president of the South Carolina Board of Medical Examiners, the chief of SLED, a sheriff designated by the Sheriff's Association, the commissioner of the Department of Agriculture, a patient representative appointed by the governor, an industry representative appointed by the governor, an individual selected by the South Carolina Advocates for Epilepsy, a certified public accountant or an attorney, a representative of the African American community, and I believe when the senator from Spartanburg offers up his pharmacy amendment, we're going to include on this commission representation by the pharmacy sector, which I think would be appropriate given what's anticipated to be the pharmacist's involvement in the dispensing process. Section 44-53-2350 sets forth where DHEC will promulgate regulations in order to take applications for individuals who want to be licensed as a grower, a processor, a dispenser, a transporter, or an independent lab testing cannabis products. And it sets forth the various criteria and factors that DHEC will consider when establishing how those licenses or applications will be processed. This would be the section of the bill, 44-53-2350, that senators may want to draw an amendment to if they wanted to establish a preference for individuals who resided in South Carolina. If you wanted to give a weighting or a preference or a bias toward individuals who live here as opposed to individuals who don't live here, this would be the section that you would direct your attention to. That particular section also talks about, and I've already gone over this earlier in regard to logo, advertising, and signage, requirements that, certain slang or marijuana leaves or things of that nature not be used in regard to the packaging or structures, prohibition against neon-colored signage, logos, packaging. Again, the thought here was that appearance matters, and we're treating this like medicine. We want it to be viewed by patients and by the public as medicine, and that having these associated marketing things that maybe some of us have seen in other states isn't something that's conducive to that sort of environment. And so that's why that language was added, because perception matters, image matters, the way the public views this matters. And so one of the things we're emphasizing to the public is this is a strictly regulated authorization for patients to use medical cannabis. It's medicine. And so we think if that's what it is, then the way it physically appears or manifests itself out there in the marketplace needs to conform with what our intent is. And that's what that section refers to. It also sets forth various standards for the independent testing laboratories. These are the laboratories that come in and inspect all cannabis products for purity, safety for human consumption, also for labeling in terms of, what the ratio of THC to CBD is in each one of these products. Every product that is purchased by a qualifying patient from a pharmacist or a dispensary is going to be properly labeled so you know exactly what you're getting. That's another thing that we've heard about some other states is that things weren't properly labeled or people didn't really know what they were consuming. They took an edible and it affected them in ways they didn't anticipate. There is information here trying to be put on the packaging to avoid that particular situation. Let's see. We talked about you can't use any images designed to appeal to minors. I talked about that earlier. Okay, section. This is still in section 44-53-2350. This subparagraph D talks about vaping and restrictions on vaping. And it's important enough that I'm going to go ahead and read it in its entirety, or I can direct your attention to it. It's subparagraph D. It says, after consulting with public health experts, medical professionals, and analysts who conduct health and safety research on vaporizers, reviewing federal regulations governing electronic nicotine delivery systems, and reviewing some other states' regulations on medical cannabis vaporization, DHAC shall, or the department shall, promulgate regulations to foster the health and safety of patients using medical cannabis vaporization products. The regulations include mandating that all models of vaporization devices sold by dispensaries must be subject to laboratory testing, including stress tests and shelf life tests, requiring laboratory testing of medical cannabis cartridges that are allowed to be used with vaporization devices, including testing of aerosol-sized products, banning all additives, cutting agents, and flavorings that are known to be harmful, creating a list of any non-cannabis ingredients that are permitted to be included in a medical cannabis cartridges which have been identified as safe for inhalation, and specifying the proportion of those ingredients that are allowed in each cartridge, issuing standards for heavy metals included in the hardware, and developing warning labels that must be included on vaporization devices, including detailing any known risks. I mean, this is the, if you'll recall, a couple of years ago, there were vaping incidences. And for a while, that was a topic of, how can we go ahead and establish some safety protocols in regard to vaping? That's the section of the bill that relates to that. And again, I'll give you the reference. It is section 2350, subparagraph large D, and then there are various subparagraphs 1 through 6 under that. That all relates to vaping. So if you're someone who has concerns over vaping, that would be the section of the bill that addresses that. Section 44-53-2360 goes into more detail in regard to DHAC establishing standards for and licensure of 5 independent testing laboratories to test cannabis products that are sold in the state. And then it talks about what the testing laboratory must pick up and test for, and it's the following. The concentration of THC and CBD, whether or not the testing material is organic or non-organic, moisture content, allergens, potency, any foreign matters, including heavy metals, microbiological screening results, residual solvent testing results, the presence and identification of fungi, including mold, the presence or concentration of fertilizer and other nutrients. And again, we didn't reinvent the wheel here, and neither did DHAC. We looked to other states and borrowed language from other states that had the highest possible standards in regard to testing the cannabis products for safety by the consuming public. And so this was the work product that grew out of those efforts. Section 44-53-2070 talks about the department shall require the use of a single real-time seed-to-sale tracking system used by all medical cannabis establishments. So this is what you often hear about, how technology today is such that you know in real time exactly where something is from the time it's a seed and it's planted to the time that it is dispensed to a patient who's been qualified to receive it. You're going to know exactly where that product is at all times due to the seed-to-sale tracking program. That's important because obviously we don't want diversion. We want to reassure the public there's not going to be diversion. This is a way to accomplish that objective, to require that seed-to-sale tracking system be used by all medical cannabis establishments. And by all, that means any medical cannabis establishment that comes into possession of cannabis, whether you are a grower, a processor, a dispenser, an independent lab that's testing it, or you're a transporter, you're all subject to this seed-to-sale tracking requirements. And the rest of the section talks in more detail in regard to that seed-to-sale and how that works in real time. Again, if you're interested in that aspect, it's, again, section 44-53-2370. Section 44-53-2380, again, talks about if you're a cultivation center, if you've been licensed by DHAC to be a cultivation center or a grower, and if you conform and comply with all the requirements of this bill, that it is not going to be, it is not unlawful then for you to possess, plant, propagate, cultivate, grow, harvest, produce, process, manufacture, compound, convert, prepare, pack, repack, transport, or store cannabis. So in other words, if you are a duly authorized medical cannabis establishment and you've been authorized either to grow, to process, dispense, it is not unlawful for you then to have possession of the cannabis for that purpose. Section 44-532390 talks about the number of licenses that can be issued to medical cannabis establishments. Only 15 cultivation centers, so 15 centers that could grow the cannabis, 30 processing facilities, 30 facilities that could be licensed to process the cannabis into medicinal or oil consumable form, 4 transporter licenses, individuals that transport the cannabis from the growing facility to the processing facility to the dispensing facility, and 1 dispensary license for every 20 pharmacies. Now, again, this is going to be subject to the amendment that the Senator from Spartanburg has been working on, and 5 independent testing laboratories. Wanted to keep the universe of, or the number of qualified medical cannabis establishments relatively small to begin with, so that DHEC and SLED and other state officials could control the situation and monitor the situation adequately. A lot of states have unlimited number of licenses. I mean, it's just the Wild West. If you want to if you want to grow, if you want to dispense, if you want to process, you submit your application, you get a license. That's not the way we went here. We went with a tight universe, a specific defined number of medical cannabis establishments because, again, this is something new. It's a cautious first step. We didn't want to subject DHEC to something overwhelming, which again goes back to the point made by the solicitors in their letter, was that they were concerned that DHEC was going to be saddled with something that they weren't up to handling. I guess my response back would be there are revenue sources in the bill that would give them the resources for administering the program, and that the applicants and the medical cannabis actors themselves are constrained in number, again, to facilitate that oversight by DHEC as we're first starting this program. So I offer that as an additional response to the point made by the solicitors in their letter. That same section, 44-53-2390, states that one of the things that it states that is that any proposed medical cannabis establishment shall not be within 1,000 feet of a public or private school. So there is a distance requirement there for those who were concerned throughout the process of proximity of medical cannabis establishments to schools. Looking further at section 44-53-2390, subparagraph I, this goes to the point made by the solicitors that an individual who's got a felony drug-related offense could be a medical cannabis establishment operator if that drug-related offense had been completed, including any term of probation or supervised release at least 5 years prior to the application being made. The point made by the solicitors is there is a lifetime ban in regard to such felonies in other sections of the code. Those of you who agree with the solicitor, that's the particular section of the bill that they have that particular concern in regard to. Section 44-53-2400 talks about the due diligence that is done every time an applicant submits an application to become a medical cannabis establishment. There is a SLED background check, an FBI background check, various other restrictions, including the one I referenced in regard to a previous felony-related drug offense, and various other things, other compliances that need to be made there by the applicant. 44-53-2410 establishes that DHEC is responsible for performing inspections of medical cannabis establishments and investigating suspected violations of the article. So the police power, so to speak, in regard to monitoring participants in the program, these licensees, falls upon DHEC. It gives it to DHEC. Okay, 4453-2420, again, reiterates that a medical cannabis establishment must not be located within 1,000 feet of a school. 4453-2430 talks about, okay, this talks about no local government may prohibit medical cannabis establishments either expressly or through the enactment of ordinances or regulations that make their operation impractical in the jurisdiction. So this is the section that those of you who are concerned with home rule aspects of this might want to direct your attention to. What this section says is a local government can zone where it wants a medical cannabis establishment to go. That falls within their land use police powers. But it says that it cannot use that power to completely deny a medical cannabis establishment from locating anywhere within the municipal limits. I believe that that's appropriate because we're talking about getting access to medicine to people. Those individuals who are concerned with home rule aspects and wanting local governments to have more control over that, that's the section you'd want to look to, 44-53-2430. The 44-53-2440 talks about various security measures that medical cannabis establishments have to have. They have to develop those security regulations after consulting with and receiving input from SLED. This is in regard to the security of the facilities themselves and the security of the harvesting, the processing, and the packaging at a secure facility. And again, SLED has the right to monitor and have input in regard to that process. It further says in subparagraph C of that particular section, again, that section's 44-53-2440, says as follows: all medical establishments are subject to random inspection by the department and SLED in accordance with regulations promulgated by the department, which shall be developed by the department after consulting with or receiving input from SLED. So in other words, SLED has at all times the right to randomly inspect these medical cannabis establishments. Again, that goes to the security aspect of this and wanting to ensure there's not diversion and ensuring that holders of licenses to have medical cannabis establishments are conforming with the law. Section 44-53-2450 requires that a cultivation center and processing facility conduct routine testing of cannabis and cannabis products at an independent testing facility in accordance with department regulations. That again, that talks about the interaction between these independent labs and the product being produced by growers and processors, the obligation of those establishments to work with those independent labs in order to allow those labs to certify it's safe for human consumption, no adulterants, and that there's the proper ratios of THC and CBD that are listed in the packaging. Section 44-53-2460 talks about what cultivation centers do with cannabis scrap and other parts of cannabis that's not being used in the production of medicine. It talks about how they're disposed of. It provides the things that they have to do in that regard. Section 44-53-2470 was my initial attempt to try to bring the expertise and experience of pharmacists and other medical professionals like nurse practitioners and physician's assistants into the dispensing area. I mean, we wanted that expertise there at that patient level. Again, this will be superseded by an amendment that I know that the Senator from Spartanburg is going to offer in regard to putting pharmacists or state licensed pharmacists in charge of the dispensing process. Section 44-53-2470, subsection C, also reiterates that all items sold at a dispensary must be properly labeled and contained in child-resistant packaging. That goes to the point the solicitors made that they wanted it in child-resistant packaging. It also talks about how the percentage of THC and CBD has to be listed on each of the products. Again, other restrictions in regard to, child-resistant packaging, conspicuous statement on all products that say for medical use only, keep out of reach of children, not for resale. I mean, just warnings in that regard. Section 44-53-2480 talks about at the dispensary level or at the pharmacy level, pharmacist level, if the amendment is adopted, there must be a flyer that is issued that contains certain baseline information about cannabis to further inform the patient as to what the effects of cannabis on them might be. Now, of course, that patient would already be getting information from the physician, would also be getting information from the pharmacist. But in addition to that, this section requires that there be a flyer that has information provided on it as well. Section 44-53-2490 talks about the penalties that can accrue to medical cannabis establishments if they violate any of these provisions. There can be revocation of licensures, monetary penalties, and other fines established by DHEC for violation of these requirements. Section 44-53-2500 talks about DHEC seeking, says it may develop and seek federal approval for and carry out research program relating to medicinal use of cannabis. Again, this speaks to an important part of this process. There is still a lot of research to be done on cannabis. There are still a lot of things that we don't know about their medical properties. And this is stating that it is the desire of the General Assembly that DHEC avail itself of any federal research programs that might be available to kind of flesh that out. And here we're primarily talking about USC School of Medicine or Medical University of South Carolina, who are already doing research in regard to cannabis, but this encourages them to continue to participate in those programs. Section 44-53-2510 requires DHEC to provide a report to the General Assembly by the second Tuesday of each year addressing the effectiveness of the medical cannabis program. So I think that's important because we need to know as a General Assembly on a regular basis, on an annual basis, from DHEC, the agency charged with administering this program, just how the program is working. To kind of keep us informed in regard to, is it operating as we expected? Are the outcomes as we anticipated? Are there things that could be better? Are there unintended consequences? So this is a recognition that this is a new program, and it's especially important that DHEC provide us on an annual basis, feedback in regard to how what we have enacted in law has worked in practice, and that's section 44-53-2510. Finally, I know you're happy to hear that. Let's see, finally, we got some boilerplate language in regard to severability clauses. We added another, if you'll recall, another section in the committee amendment that states as follows. That's in that last section. It states that again, one of the things stated in the committee amendment in section 44-53-2070, nothing in this article may be construed to require a health care insurance provider, health care plan, property or casualty insurer, or medical assistance program to be liable for or reimburse a claim for the medical use of cannabis. Again, this was at the request of the insurance industry. And then we added a new section, I believe it would be the very last section, maybe section 9, that, sections 1 through 8 shall be repealed by operation of law if a federal court, pursuant to a filing by the United States of America or one of its authorized executive agencies, issues a final order declaring that those sections have been preempted by the Federal Comprehensive Drug Abuse Prevention and Control Act of 1970, more commonly referred to as the Controlled Substances Act. And again, I went through at the very beginning last Wednesday the reasons why. In this case, the CSA on its face states that it does not preempt the field, that it does contemplate state action in the field of controlled substances. I also reviewed the case law in regard to implied preemption, whether that's obstacle prevention or impossibility prevention. And according to that case law, that would not apply in regard to this bill. So Members of the Senate, that's my detailing.
Senator from Anderson, what purpose do you rise? Senator Cash.
See if the senator would yield for some questions.
Senator yields.
Senator yields.
Senator, it's a comprehensive bill. It is hard to digest. I think you would acknowledge all at one time. No doubt that's why it's taken us several days just to allow you to get through an initial explanation of the bill, and that's before those rise to speak who are against the bill. But I do want to try to clarify some things.
Sure.
Try to understand your thinking. I will ask a few questions, and that might help me as to whether or not I draft an amendment on some of these questions. I want to go back to the beginning, the definitions part, where you're saying that defining the cannabis products and how much THC they can have and so on and so forth. And let me try to articulate my concern here. In the certificate that a doctor is required to fill out, it actually says that a physician may also choose to include a specific amount of cannabis products certified every 14 days. I mean, that's section 4453 2080.
Subparagraph B.
Subparagraph B. It doesn't say that he must. I mean, it says that he may do that, but he may not as well. He just may certify that someone can have access to the cannabis products without saying how much they can get. And my concern is, when you go back to these definitions, it gives an amount for every 14 days that people can get for topical administration, oral administration, oils, etc. Different categories depending on how it's going to be applied. And so the way that I would put those two sections together, if the physician does not say how much the dosage is, so to speak, if he can say how much, he may say, but he may not, then that would allow, is the way I understand this, a patient could get all of these things, a supply of 14 for all of the cannabis products. Now, tell me what your thinking is about this. I know you're going to emphasize the physician, but your thing here says the physician may, but does not have to indicate what the patient should be getting.
All right, let me do the best I can to explain that, Senator from Anderson, is that I would think that the default setting, or what is going to be in most cases, is that a physician is going to go through that diagnosis and that what we've been through, authorize and say, yes, the patient has one of these qualifying conditions, and based on this patient's medical history, I think the cannabis can be a benefit. And in most cases, that's going to be all the certification says, and that certification is then taken down to, in this bill, a dispensary, or if the amendment is adopted, to a pharmacist, and that at that level, there'll be a determination made by the patient as to what form of cannabis that the patient wants to consume, whether it's orally or a lotion or something that can be vaped or a tincture. And there would also be a determination by the patient at that level of the ratio of THC and CBD that would be used. And again, this is where we get in. So that's the usual. I think that I would anticipate that being the usual case, and it would then be incumbent upon the patient interacting with the dispenser and figuring out what mode of consumption was most efficacious, what ratio of CBD to THC was proper for that person's endocannabinoid system. And I think that's a good argument for the proposition that there ought to be a pharmacist there with the experience that a pharmacist has in interacting with a patient. But what this bill, to your point, Senator from Anderson, says is that a physician may want to do more than just that, may want to do more than just authorize, and that a physician may in fact want to specify a certain amount of cannabis products. And I guess my best answer would be that would vary with the physician. It would vary with the degree of confidence the physician had with what sort of cannabis and what ratios would be most effective. So that's why it's discretionary. It is not mandatory that a physician do that, because all a physician has to do is authorize, and then that specificity occurs at the dispensing level. But that having been stated as the general rule, it is then stated that a physician may be more specific than that.
Senator, I appreciate the explanation. I think you might understand how that's going to raise some concerns, because several times you indicated the patient needs to decide whether it's topical, oral, and the patient needs to decide, how much CBD and THC, percentages they want in the product. Now, I anticipate the amendment with Senator Kimball because I spoke to him for 30 minutes this morning.
Yeah.
So I anticipate that we're pushing this over from a dispensary agent who, by the language of this bill, had no training at all, that I can tell, to a pharmacist. Now, I don't know what that amendment's going to say about a pharmacist training. I know that, as far as I can tell, a physician only has to have 3 hours of training to be qualified to write a certificate. And I think there's going to be some concern as to how much training a pharmacist should have to have, who is going to be, I think perhaps you would agree, the primary person who's then going to engage with the patient to say, well, how are you going to take this, and how much of this are you going to take? Would you not agree that we're going to have some discussion about
I think that's
education for the dispensing agent?
Yeah, I think that's fair in both respects, in both in regard to the physician and in the amount of education the physician has in regard to making that certification. And I think you make a valid point in regard to if it's a pharmacist, and for the sake of argument, I'm going to assume it's going to be that, whether or not the amount of education we're requiring is sufficient in order for that pharmacist to discharge what the expectation is. Because I'll frankly admit, you're right, that unlike with a lot of other prescriptions that doctors issue, where there's a great degree of specificity on the front end by that physician in regard to, not only the type of medication, but how often a day the patient takes that medication, that's not going to, by and large, be what we're talking about here. What we're talking about here at the physician level is an authorization that, yes, given your condition and given your medical history, it is that physician's medical opinion that medical cannabis can be efficacious. But to your point, the exact mode of taking that cannabis, whether it's an oil or a vaped or tincture or whatever, and the ratios of the two primary chemical components of cannabis, THC and CBD, a lot of that is going to take place of necessity at the dispensing level, at the pharmacy level, because cannabis acts so differently with everybody's endocannabinoidal system, and everybody's endocannabinoidal system is different. And so what may work for you, if you had irritable bowel syndrome, and what worked for you was, a ratio of 15 to 30 of THC to CBD, that may not be what works for me if I go down there with the same condition. And there's going to be a degree of trial and error there, and that really speaks to the wisdom, I think, of having a qualified medical professional at that dispensing level, at the pharmacy level. And we can have a talk about what sort of education is going to be sufficient in order for them to fulfill what we think they should do.
Sure. And I appreciate your comments, and I will be interested, to see what the senator from Newberry thinks about that, because, right now we're talking about 3 hours of education for the physician. Senator, I'm just going to bring this up, and I recall on the bill last year to allow pharmacists to prescribe birth control pills. They had to have 3 hours of education before they could do that, and then 3 hours of continuing education each year in order to do that. I'm not sure there's even continuing education in this bill right now, but
there is for the physician, and I think it's in there for the pharmacist in the amendment, but I would need to look at the amendment. But it's in there in regard to the physician, would have to have that annual certification of education, continuing medical education.
Okay, well, I do think, maybe in conjunction with the senator from Newberry, we're going to have some greater degree of comfort because, as you would tell us, I mean, it's not just CBD and THC. From what I've read, there's over 100 different compounds present in the marijuana, and as you've just said yourself, they might work different ways for different people. And I think I understand the basic premise here, which is maybe it's been explained as start low and go slow, in your usage of these different products to see what might be effective for someone. And I've got a feeling that if this pharmacy amendment goes through, that's going to be put upon the pharmacist really to engage more so than the physician as to what mode they're going to use and how much they're going to use. And I think we're going to have some discussion and something written in here about what a kind of education the pharmacy agent's going to have.
One thing I think I'd point out too, Senator from Anderson, and you're right, and we're fortunate to have in the body a professional pharmacist that can really inform us on that. But one of the things I would point out is the requirement that after a physician authorizes a patient to use cannabis, and after that patient then goes to a dispensary or to a pharmacist and gets that cannabis, there's a requirement that that patient can then go back to the physician for a follow-up appointment. So I would anticipate there's going to be the opportunity for conversations between the pharmacist and the physician, as well as with the patient, in terms of that going back to the physician within 6 months after the initial authorization. So what I would imagine is you're right. I think a lot of it occurs at that dispensing level in terms of testing and seeing which efficacious, but there is that information loop back to the physician put in here for that reason, and that I wanted there to be an information feedback from that dispensing level back to the physician.
Senator, we touched upon this a little bit the other day, but I just want to make sure that everyone understands that the PTSD is included for first responders, but then another portion of this bill prevents someone from being a card holder if they are involved in public safety, commercial transportation, or operating heavy commercial machinery. And so when I put all that together, as I understand this, people who work in public safety, commercial transportation, they can't get a card unless perhaps they're retired and no longer active. Is that the way you understand all this being put together?
My understanding would be that if you're currently employed by one of those employers, that you could not have a card, whether it's law enforcement or I think another instance was commercial trucking. And again, as I tried to say last week to Senator from Charleston, there's a balancing act here between trying to get medicine in the hands of people who need it and really, quite frankly, deserve it, and the concerns that have been expressed by certain types of employers in regard to what the use of cannabis by one of their employees might be in the performance of their duties. And I've tried to strike that balance. I don't claim that this bill is internally consistent in all its respects, but in each case, what I've tried to do is listen to concerns expressed by stakeholders and try to accommodate those concerns, because I recognize that a piece of legislation like this, if I want it to pass, and I do want it to pass because I want to start getting relief to people, it's going to have to take into account the concerns that are expressed by powerful constituencies if it's going to have a chance.
Sure. Going further in the definitions, I want to get clear in my mind what's meant by the word physician. I didn't have time to go study the code that refers, when I think of physician, I think of someone who, for lack of a better expression, is board-certified medical doctor. Now, is that what is meant by Section 40-51-20, which is what it's referenced to? This is definition number 25, right, physician.
Yes, I have that. That is, and what I would further say is,
or a podiatrist. Can you clarify why a podiatrist is mixed in there with physicians?
The physicians, I guess the short answer to your question is the podiatrist indicated an interest as a profession in being an authorizer. I mean, that's the answer there. In regard to physician, I believe that your interpretation is that it is somebody who's been authorized to practice medicine by the Board of Medical Examiners. And then also, it has to have, in regard to authorizing a patient to use cannabis for a condition, the condition for which it is authorized must be within that physician's area of practice or specialty or expertise. So there is that restriction placed on it as well. Again, fair point. I mean, we're talking about who the gatekeeper is going to be, and you know, do we tightly enough define that gatekeeper? Do we confine the number of individuals who qualify to be that gatekeeper appropriately? And I think you raise a good point. I mean, we can have a discussion on here as to whether or not it's appropriate to include podiatrists within that particular universe of authorizers. I think that's a fair point.
I want to move over to the advisory board for a minute.
What section is that, Senator?
It's 4453-2060, the Medical Cannabis Advisory Board. I'm not trying to be too picky, but I do want to know or ask, should we not stipulate how the chairman is appointed? Because it's not in this language as to, I mean, you've got 11 members here. I think it needs to say, you know, if the governor appoints the chairman of this board, I think there needs to be a chairman of the advisory board. That might need to be in here somewhere. And then the only other question I would have that I think maybe needs a little thought is whether this board really needs to meet twice a year, because this foresees that the board might need to be doing studying to add additional conditions and having even public hearings as to whether or not certain conditions should be added. And, you know, these people are volunteers, you know, other than getting some mileage and stuff. Do we really need them to meet a minimum twice a year? Could this be done once a year? And as part of this ongoing study and review of the study that's ongoing and being published all the time, you know, the language allows for additional conditions. Would the language ever allow for conditions to be removed if the studies show that, all right, we've had enough study to know this is just not a condition that's helped? It shouldn't be on a list.
Yeah. I think to your point, I think, and I had that conversation with another senator, senator from Spartanburg, who also brought that point to my attention quite reasonably, that if we're going to charge this commission with following where the science is and making recommendations as to additional conditions that could be treated by cannabis, the converse ought to be true as well, that if medical science further develops and it turns out that, you know, it's not going to be efficacious, then I agree that we ought to add that as well. I think that's a fair point.
Senator, I've got additional questions, but I think the majority leader here might want to be concluding here very shortly.
Oh, what time is it? Time flies.
Senator from Spartanburg, Senator Martin.
All right.
Thank you. You're very kind. Thank you. Senator from Edgefield, what purpose do you rise?
Mr. President, with the senator from Beaufort retaining the floor, I would ask unanimous consent that if and when the Senate adjourned today, that it adjourn to meet at 11:45 a.m. tomorrow to gather for the joint assembly, and that the Senate would reconvene 1 hour after the joint assembly concludes.
Unanimous consent request without objection. So ordered. Senator from Edgefield.
Mr. President, the Finance Committee, I think Chairman Peeler has a meeting that's scheduled at 3 o'clock that I understand the Finance Committee needs to get to deal with some federal funds that are out there. So this is probably a good time for us to break for today and then get back on this conversation tomorrow. I know there are senators who still have questions for the senator from Beaufort. Hopefully we can do that tomorrow, and maybe other people want to speak and maybe even get into some amendments. Hopefully we can get into that. So hopefully we can spend several hours on this tomorrow and see how things move along. But it's probably a good time for us to quit today. So I want to see if anybody has a unanimous consent request before we do that.
Seeing the senator from Cherokee.
Finance Committee will meet at 3 o'clock, room 308.
308 at 3 o'clock. The Senator so notified the Finance Committee. Thank you, Mr. Chairman. Senator from...
Mr. President.
Senator from Edgefield.
Mr. President, with the senator from Beaufort retaining the floor, I move the Senate adjourn.
Unanimous consent request. Without objection, so ordered. We are adjourned until 11:45 a.m. tomorrow, Wednesday.